Good afternoon to all the participants that have joined us to this conference organized by the German Arbitration Institute, DIS, and the Madrid International Arbitration Center, MIAC. We are delighted to have you on board. The purpose of the present conference is to present to you this esteemed organization, always to flesh out their advantages when administering an arbitration procedure. Likewise, we want to explore, along with our experts, and the attractiveness of Germany and Spain as a seat of an arbitral tribunal by acquiring and understanding what exactly these countries have to offer to users and practitioners. This part will be followed up by a Q&A session in which we warmly encourage you to send your question using the chat function. I will read out loud your question and address it to the selected member of the panel. Finally, we will have some closing remarks. Just for your information and to ensure that the conference will run smoothly and without interruption, you will be set on mute. As mentioned, if you want to participate, just use the chat function, which will be enabled throughout the entire conference. So let's start. So we are very keen to commence the conference with a brief introduction made by Dr. Fabian von Schlavrendorf about the German Arbitration Institute, DIS. Dr. Schlavrendorf is a member of the DIS advisory board, and he has been involved in the work of the MIAC's commission named Examen Previo de Laudos. He currently works as an arbitrator and has been a long member of the ICC International Court of Arbitration. So, Fabian, the floor is yours.
Thank you. A most warm welcome, dear ladies and gentlemen. As you might have seen from the program, Herbert Kronke was supposed to take this part in the conference. Unfortunately, he's not able due to sickness to be here today. So I talked to him this morning, and he sends the best wishes to all the participants and to the success of this webinar. Let me start with an observation of a general nature, and that is the enormous potential of bilateral meetings such as the present one. It's filled with experts who know a lot about arbitration in Spain and in Germany. This is true, that this seminar can be so fruitful for us, even in times in which, instead of visiting Madrid in its best period of the year and enjoying the fantastic hospitality of our Spanish colleagues, we are bound to hold a virtual meeting only. The value of today's meeting, Spain-Germany, lies in its capacity to provide us with most direct insights from our neighbors about the state of affairs in arbitration matters in these two European countries. Details not always easily accessible and often not found in books. To know such details about these two arbitration jurisdictions is of relevance with regard to many aspects of the practice of arbitration relating to these countries, of course. I submit, however, that such knowledge is of foremost importance when drafting arbitration agreements. When the moment arises when we are called to make a choice as to the possible seat of the arbitration envisaged. I look forward to hearing from our excellent speakers today about the status, advantages, and disadvantages of Spain and Germany as seats for international arbitration proceedings, covering aspects such as legislation, the courts, and arbitral institutions. As an introduction to their analysis, which is likely to cover the most important of these aspects, let me just emphasize the predominant significance of the institutional arbitration offered in each country. Institutional rules tend to replace many of the default rules found in the legislation and therefore more accurately reflect the actual state of affairs in arbitral practice in a specific setting. In addition, the question what kind of arbitral institutions exist in each country and their activities reflect on the culture of arbitration in each country concerned and allow us to conclude as to how much freedom the courts grant the parties in agreeing on arbitration and in finding out which arbitral practices are considered to be acceptable. With this general background in mind, standing here as a speaker for DIS, allow me to make the following general observation about this particular arbitral institution and its significance for Germany and arbitration in Germany. It is generally accepted in Germany that DIS is the relevant national arbitral institution. Its origins going back to predecessor organizations some 100 years ago even. There are other smaller and specialized institutions in Germany, some for specific industries, others aimed at serving parties from specific countries. But none of these institutions aims at providing general arbitration services for national as well as international arbitrations. DIS also administers sports arbitrations and offers rules on ADR, among other special rules. In the recent years, the number of incoming arbitration cases oscillated in the region of some 150 to more than 160 new matters each year. The most significant 218 reform of the DIS rules did not only bring about a reformulation of the arbitration rules as such, but implied a significant step in the direction of strengthening the role of the institution and the scope of the administrative process. In short, the new DIS rules represent a much greater deviation from the 10th book of the Civil Procedure Code and its default rules for ad hoc arbitration than ever before. Emphasizing the independence and integrity of their members, two new bodies have been created within DIS, the Appointing Committee and the Arbitration Council, which is formed by a minimum of 15 members and which is charged with rendering decisions inter alia on challenges and arbitrators' fees. Similar to the MIAC rules, the tribunal has to submit its draft award to the DIS for review. The institution may call attention to aspects of form and may propose non-binding amendments as to its contents. Another significant aspect is also that the 218 rules provide that the sole arbitrator, respectively the presiding arbitrator of a tribunal, shall be of a nationality different from that of any party, unless all parties are of the same nationality or have agreed otherwise. And a key provision of procedure, according to this, is the requirement for the tribunal to hold a case management conference with mandatory content. The tribunal is required to discuss steps towards more efficient arbitration procedures with the parties, as for example, laid out in Annex 3 to the rules, which contains the whole toolbox of measures to be taken by a tribunal, such as limiting the length and number of written submissions, written witness statements, limitation or dispense of document production, and the issue of an order to take evidence, which is not a commonly used tool in international arbitration, but which serves very well to focus the oral hearing on the relevant issues under the law. Included is also the possibility to discuss in this case management conference whether the parties would opt into the expedited procedure, which is also offered by the rules. Now, in contrast to the impression one might have of DIS being an arbitration institution of national character only, it has evolved over the years as a more and more internationally active institution. The share of proceedings involving foreign parties has continuously risen from 33% in 2010 to 49% in 2020, with parties from China, Great Britain, and the Netherlands taking the lead. In contrast, parties from Spain or Latin America have been involved much more sporadically. Just to give you some numbers, in 2017, there were 2 Spanish parties, 1 Mexican party. In 2018, 1 Spanish party, 1 Mexican party, 1 Brazilian party. In 2019, 1 Spanish, 1 Mexican, and in 2020, 1 Brazilian and 1 from the Dominican Republic. So it shows you that the active involvement of the Latin world in DIS arbitration is still quite limited. But there is a general internationalization, and this is reflected in the composition of the DIS team, which comprises 10 different nationalities and 10 different native languages spoken. The aforementioned DIS Arbitration Council, which must have comprised at least 15 members, must by rule have at least 5 members from countries other than Germany. And these are currently members from Sweden, Switzerland, Italy, Russia, France, United States, Greece, and Poland. An additional distinctive feature of the new DIS rules is its encouragement of settlements. If no party objects, the tribunal shall at every stage of the arbitration seek to encourage an amicable settlement. The provision of Article 26, however, leaves it clearly to the parties to determine if and how they want negotiations to take place and what role the tribunal could have in this context. Therefore, this provision is in line with the views on the possibilities of settlement as it is in particular shared in common law jurisdictions. And this is where I want to conclude my remarks and would like to hand over the baton to my friend José Antonio. Thank you very much.
Thank you very much, Fabian. I will take over for a few introduction, but first, thank you very much for this overview and insights, and also these relevant facts about the DIS. And I duly took note about my Colombians not using the DIS until now. So there is a bit of work to be done there. So now it's my pleasure to welcome Mr. José Antonio Caínzos, who is the president of the Madrid International Arbitration Center. He is also founder of the firm Caínzos LDR. He has over 25 years of experience as counsel and also as an arbitrator, and have participated in more than 170 cases in many international and domestic arbitration courts. José Antonio will introduce us to MIAC. The floor is yours.
Thank you, Elizabeth. Well, first of all, thank you very much to DIS And thank you, Professor Herbert Kronke, that unfortunately cannot join us today. Thank you to my friend, Fabian Fonges Lavendor, that is today representing this institution. Thank you to the panelists, Mr. Scheffer, Mr. Florisdor, Ms. Incapié, Ms. Lopez Castro, Mr. Heinrich, and Mr. Gamero. And thank you also to the whole team that has prepared this webinar, particularly Mr. von Essen. And of course, thank you to all the attendants to this meeting, to this webinar regarding Spain and Germany as seat of arbitration. The story of this virtual meeting started some months ago, in November of last year. I sent a letter to Mr. Kronke introducing MIAC and offering our sincere interest in finding joint working channels. Mr. Kronke, and I apologize for the pronunciation because probably it's not correct, very kindly answered to my letter immediately, offering to organize a virtual meeting to present both institutions and looking forward ways of cooperation. And here we are. That's why we are some months later, because the team has been preparing all the details in order to make sure that this webinar would be useful for the attendants. Well, regarding MIAC, I have to say that MIAC is an institution that acts both as international arbitration court and as international mediation service provider. MIAC has started functioning on the 1st of May of 2020 as a result of the merger of the international activity of 3 Spanish courts: the Madrid Arbitration Court of the Madrid Chambers of Commerce, the Spanish Arbitration Court of the Spanish Chambers of Commerce, and the Civil and Commercial Court of Arbitration, CIMA, that is a private institution with a lot of experience in this arbitration field. But also MIAC counts with the support of the Madrid Bar Association. That's why I always say, I like to say that this is a project prepared by businessmen and lawyers for businessmen and lawyers, because as you see, 2 of the institutions are supported by chambers of commerce and 2 are supported by institutions, the Bar Association or another private institution of lawyers. Which is the purpose of MIAC? Well, I have to say that MIAC's vocation is to become the natural Spanish international arbitration and mediation court and service. Our offices are located in Madrid, and one of MIAC's objectives is clearly to promote Spain, and Madrid in particular, as a seat jurisdiction for international arbitration and grow into the leading Spanish-speaking international arbitration institution. Nevertheless, MIAC also develops its tasks in English, Portuguese, and French, and desires to become an authentic international institution. Why MIAC considers that this a real international institution? Not only because the work is done in 4 languages, is because the founding courts of MIAC has a lot of experience, approximately 20 years of experience in international arbitration. So our team is trained in has been trained in international arbitration for so many years. Although this is a Spanish institution based in Madrid, our focus is international arbitration and mediation. And we, of course, MIAC apply any law agreed by the parties. The seat of arbitration could be any city in the world, for instance, any German city. And our commissions are composed of personalities from 25 different countries of 3 continents. A lot of people from America, particularly from Latin America, but also from the USA. A lot of members from different countries in Europe, and also some members from Asia. And well, we think that this is extremely important because this purpose, this task of becoming international institution for us is quite important, but we think that it will only be possible if we work from the very beginning as an international institution. And that's why we have a number of ongoing projects that reflects this idea. Very soon, this month, will be launched the project that we call Friends of MIAC, in order to set up groups of people in different countries that want to support MIAC and to explain what is MIAC and how it works in their jurisdictions. We have also set up sectoral working groups where we join in-house lawyers, business people from different countries in different sectors of the economy, with lawyers, counsels, and arbitrators that are specialized in that area, in order to know what they look for when they think of solving disputes in arbitration or in mediation. Currently, we have 6 groups about maritime law, construction and engineering, energy, tourism and real estate, digital economy, and the pharma sector. And in the coming weeks, during this month of May, at least 2 other groups will start working, the Defense and Security group and the Financial Institutions group. In these groups, we have people from companies, for international companies, and also counsels and arbitrators from different countries. We have also started working in a number of sessions with experts from different areas in order to discuss the role of experts in international arbitration. We have prepared 2 sessions, and the idea is to have at least 6 sessions in the current year, with people attending these sessions from different areas, economy, engineering, and others, of the best companies in the world. And, well, you know, this is also important for us because we, from the very beginning, we have a very clear idea. We have the biggest appreciation for the widely recognized international arbitration courts that have initiated the activities before us. And therefore, MIAC greatly appreciates to entail a fruitful relationship of knowledge and cooperation with DIS and with other institutions, because we are convinced that the synergy of all the different stakeholders that promote international arbitration and mediation within the highest ethics standards, transparency, commitment to serve the users, excellence, and efficiency will benefit in the reputation of acceptance of these dispute resolution methods. The maintenance of the recognition for these services requires that all stakeholders work and act together. That's why we are here in this virtual meeting with DIS. We have also arranged meetings with Hong Kong International Arbitration Center, with the PCA of The Hague, and we are currently preparing a number of sessions with Latin American courts. So, as you will see, we are plenty of energy. We have a lot of ideas, a lot of projects, and we look forward to continue cooperating with DIS in the coming future. Thank you very much.
Thank you very much, José Antonio, for this general overview, for presenting us these interesting projects that you have along the way. And yeah, to show to us all the advantage that the MIAC has to offer, not only to the practitioners, but also to in-house counsels, and of course, at the end, the users of arbitration. Okay, now I will use this presentation as the perfect bridge to the next part of this session in relation to the advantage to have either Germany or Spain as seat of the arbitration. We will also be addressing the latest development in case law in both countries. And that's why it's my great honor to introduce to you to my respected panelists, starting with Ms. Heidi Lopez Castro, who is counsel at the International Arbitration Department of Uria Menendez in the office in Madrid, and in lecture in different universities. She specializes in domestic and international arbitration and also in international litigation. Heidi has participated in commercial and investment arbitration proceedings with seats all over the world, especially in Europe, and under the rules of various international arbitration institutions such as ICC, LCIA, ICSID, and CIAM. Then we have Mr. Eric Schäfer, who is partner at Kohaus and Florak, a boutique law firm in Düsseldorf, Germany. He has a vast experience as counsel as an arbitrator in international disputes, mainly in the areas of IP and IT, unfair competition, and also in commercial law. Eric is co-chair of the Task Force on IT and Arbitration, and also co-chaired the Task Force on Expertise Proceedings of the ICC Commission on Arbitration. He is member of the Emergency Arbitration Task Force and more other memberships. He is also a trained mediator. Finally, we have Mr. Joseph Frühlingsdorf. He currently works as an arbitrator and is also the founding partner of Frühlingsdorf Abogados Asociados. He has also vast experience in arbitration, advising German, Austrian, and Swiss companies active in Spain and Latin America. Joseph is admitted to the bar in Germany and Spain and is a member of the board of the CEA Club, el Club Español del Arbitraje, member of the Pleno of the CIAM, and member of the International Advisory Board of the MIAC, the Vienna International Arbitration Center. Thank you all for being here. For all of you that don't know me yet, I am an in-house counsel working at Hardcore Rail Europe, based in Düsseldorf, Germany. I work as a head of the legal department, and I am admitted to practice law in Germany, Spain, and Colombia. And I have gathered my experience on arbitration on the perspective of the users as in-house counsel. In this role, I will be moderating this panel. So, often, when in-house counsels are drafting an arbitration clause, we usually get confronted with the question which will be the most suitable location to serve as a seat of a potential arbitration proceeding in case that the contract goes south. Normally, and depending with our experience and focus, we are more familiar with some seats and jurisdiction than with others. And comfortably, we normally propose one of those seats in the clause. But as you know, the counterparty does not always see my way. So the question arises, what to do when the desired seat is no longer available? For this, and in the ideal world, I will have the time and the resources to consult experts like my dear panelists. But often, when in-house counsel only have the time and the budget to put some facts together, and in an attempt to make an informed decision, we just don't get to these resources. That's why it's always important to be informed in advance. In this vein, I'm really happy to have this opportunity to learn more about what Germany and Spain have to offer by discussing different relevant facts and that might influence the attractiveness of a place as a seat of the arbitration. For this, I would like to start with you, Heidi. In your opinion, what makes a country attractive as a seat of the arbitral proceeding? For instance, the quality of the lex arbitri. What are your thoughts on this, especially in relation to Spain?
Thank you, Elizabeth, and thank you for the CIAM and the MIAC and the DIS for this invitation. And it's an honor for me to be in this panel with my co-panelist and with you, Elizabeth. So thank you again. Regarding your question, what makes a seat attractive. I think a couple of legal and a couple of practical reasons. As you mentioned, from a legal standpoint, I would say that one of the things to take into consideration is the quality of the arbitration law at the seat of the arbitration. So moving to Spain, and what is or how does the arbitration law in Spain looks like? We have in Spain a specific arbitration law, which was passed in 2003 and reformed in 2011, which is expressly based on the ancestral model law. It's not a copy of the model law, but it's expressly from the legislative point of view based on that law. I would say, I don't want to bother you with details, but I would say that in all the main points, it's fairly similar to the model law. A couple of ideas that I bring to your attention that are relevant. The Spanish arbitration law applies to all types of arbitration. So that's the first main difference, but it's a useful difference because we have one legal system for all types of arbitration. So it's not depending on whether it's an international arbitration or a national arbitration. We have basically the same regime for arbitrations in Spain. That's the first point. Arbitrability. The arbitrability of disputes is defined in a very similar way as to the ancestral model law. Annulment and recognition, even if it's not the same drafting, again, we have a fairly similar drafting as the model law. We don't stipulate in our law the grounds for opposing to recognition and enforcement, but we refer to the New York Convention when the award was made in the seat that is not Spain. And at the end of the day, the ancestral model law is a copy of the grounds stipulated in the New York Convention. So you see, even if we don't have the same drafting, at the end of the day, we have a fairly similar regulation as the one that you could find in the ancestral model law. And maybe the last point is regarding interim measures. You know that in 2006, the model law included some variations to its original model law. Well, Spain has not included specifically because it was already indirectly included. So Spain has always recognized and recognizes and enforces interim measures from arbitral tribunals, and also has always recognized the power of its own tribunals to issue interim orders in relation to an ongoing or a future arbitration which has been or which is in the course of being initiated. Now, I think that summarizes a little bit what you would have in the Spanish arbitration law.
Thank you very much, Heidi. Now I would like to draw a comparison line from the German perspective. So what, Eric, do you have to tell us about the Lex Arbitri in Germany, and maybe drawing some parallels to what Heidi just told us?
Well, I could start and simply say same over here. That, of course, is not the purpose. We also have the ancestral arbitration model law as basis, and we have virtually adapted the text, which is the 10th book of our Civil Code of Procedure, the Federal Civil Code of Procedure. This applies as well to internal and international arbitration procedures. The point is where the arbitration is legally seated. There are certain competences for German courts for parties who have their general jurisdiction in Germany and where the seat is not defined yet. So where we have to start arbitration without agreed seat, and there the German court will jump in. We have a limitation of what the ways a German court can intervene in arbitration. They can only intervene in regard to the default constitution of arbitral tribunals. If one party doesn't participate, for example, they can handle challenges and replacement, but this can also be delegated to arbitral institutions like the DIS, who have rules that normally are faster and more versatile in resolving this kind of situation than a state court would be. They can act as juge d'appui, which means they can help in finding evidence in Germany. If there is a witness who's not going to appear before an arbitral tribunal, they can call and force this witness to come to the court if the witness is within the jurisdiction and testify. They can also provide interim relief without that being a reason to annul the agreement to arbitrate. It's not an act that would automatically void the agreement to arbitrate if you seek interim relief. But of course, you can also look for interim relief from the arbitral tribunal, which is normally not so smooth as in German courts. German courts are pretty fast and efficient in providing interim relief. And of course, they have the authority to annul and enforce awards. The authority rests with the Oberlandesgerichte, which are the courts of appeal. They decide by an order that is subject to legal recourse to the Federal Court of Justice, but that was it. And I think this is all I would need to mention at this stage in regard to the situation in Germany. So in all, it's very similar. What is important, I believe, is German court practice in arbitration matters is well publicized and foreseeable, at least insofar as certain courts, Oberlandesgerichte, are concerned, because all decisions are published and they are congruent and normally will not be in there for a big surprise. The surprise comes with the facts of the case.
Thank you very much, Eric. So from your replies, I will say that both countries are very attractive in what lex arbitri is related, so that we don't have a important deviation, let's say, to the uncitral model law that will create some concerns.
That's right, Elizabeth. From my point of view, it's exactly that. The roles of the court, as Eric was saying, are very well defined. When they intervene, in what capacity, on what grounds, and it follows fairly, I would say, the international practice, where seats from seats that are considered keen or amiable to arbitration. Great.
So another factor that might influence the selection of the arbitral seat is the recognition and enforceability of the arbitral award. Heidi, could you please briefly explain us the recognition and enforcement procedure in Spain?
Sure, thank you, Elizabeth. So we have to differentiate two cases. First, the recognition, first the enforcement of awards that have been issued in Spain. So in this case, you don't have a recognition procedure, you go directly to enforcement. And you always obviously have the possibility to try to annul the award with limited grounds, but you don't have a recognition procedure. So in this case, the enforcement lies with the first instance courts, and it's fairly straightforward. You don't have any grounds for opposition apart from ones that would apply to any decision from the courts. And in Spain, it's limited to question of whether I can use that good or that asset to enforce the award or the other one, but it's not related to the merits of the decisions of the award in this case. So that's a very straightforward procedure. For awards that have been rendered outside of Spain, you have to go through recognition. In this case, our arbitration law does a reference to the New York Convention or any other treaties. So in principle, the competence for recognition lies in the superior courts of the autonomous regions in Spain, of the different autonomous regions that we have in Spain. This was a change that was brought to give more transparency and more consistency to the decision issues in terms of recognition. Why? Because first they the competence was with the first instant courts. There are much more courts of first instance. Their decision is not always published. So the fact to move the competence to the higher courts was to give more consistency and publicity to the decisions. In terms of procedure, so you have the recognition in the superior courts of the autonomous regions, and then you would have enforcement in the first instance courts as if it were a national award. In terms of grounds for opposition, you will have the grounds that are set forth in the New York Convention. And what I can say is that the Spanish courts are very reluctant not to recognize an award. So in the last 10 years, I've come across around a little bit less of 15 decisions in relation to exequatur recognition of foreign awards. And all of them, the awards was recognized except from 4. And 3 of them was for formal reasons. So non-valid power of attorney. And the second one, it was actually not an award. It was a decision from a specific local court of a third country. And the third one, it was not the competent courts because, and that's something worth mentioning, there are several bilateral treaties, for example, with China, Morocco, Uruguay, that specify that the recognition lies still with the first instance court. So, and that was a case where simply the competent court was not activated, it was an incompetent court. So you will see that in reality, there was only one case that was actually not recognized. It was for a reason of public order, and we will discuss this later, I'm guessing, but I'm fairly sure that if the case was brought today, that case would have been recognized today after the latest developments in Spain. And I don't know if you want to deal a little bit with what happens if the award is being annulled, or you want to leave that for later on?
Yes, just keep this part for
I'm going to keep
minutes.
it in mind.
Yeah, exactly. I'm going to revert back to you because it's a very, very important, but I was just wanted to reply to you. So you say that some awards have not been recognized due to lack of formalities. What kind of remedies you could have there? So like, for example, an in-house counsel will be really frustrated if you have done everything right and just due to a formality, like you just mentioned, like, I don't know, POA, or I got, for example, sometimes issues like, do I just need to legalize it? I need an apostille. What do exactly I need? And sometimes it's very difficult to access to this information. Can you just give a brief elaboration on this?
Yes, sure, Elizabeth, very good point. So basically the requirements that lie on the person or the entity requiring recognition of the award are the ones stipulated in the New York Convention. How do the courts interpret it? Because that's key. Well, basically, they have quite a broad interpretation, but what I would say most importantly is that the consequences are not that severe. Why? Because in Spain, you have 5 years. So that's important to know. You have 5 years to enforce a final decision. But during those 5 years, if you submit a recognition application to the courts and you are lacking one of the formalities, first, the court will give you normally 10 days to try to remedy that lack of formality. And second, even if you don't remedy it and the court has to dismiss the case, that doesn't prevent you to present it again if you are between the 5 years. So I think that, I mean, on the one side, I can say to summarize that Spanish courts will look at those formalities. They will make sure that they are complied with. They will, for example, look at the apostille. If you follow the Hague Convention, they will look at the translation and make sure it's a sworn translation. They will look that you have powers of attorneys, as you would do in any other case, but at the same time, the consequences are not that severe because you always have, in between those 5 years, the opportunity to remedy them.
That's a relief. Thank you very much, Heidi. So now, Eric, is again your turn to explain to us how these procedures looks like in Germany.
Well, you would first of all, if the award is rendered and notified, you have a 3 months period of time to challenge it on the grounds that are corresponding to the model law and the New York Convention. So there are limited grounds to resist enforcement of an award. If there is a request, a timely filed request for a clarification, interpretation of the award or correction of an error, this period of time is extended by 1 month. If you do not do anything within these periods of time, you can no longer challenge an award that has been issued in Germany on these grounds, which means there are no grounds on which you could challenge it, and the award will be enforceable as any firm court judgment. However, if enforcement is being thought, you will only have the grounds to which I just referred, which are invalidity, non-existence requests of the agreement to arbitrate, or the arbitration is not covered by an existing agreement to arbitrate. There was no notice of and no participation in the constitution of the tribunal. The tribunal was faultily constituted, or a violation of an agreed rule took place, but that violation of an agreed rule must be the object of an objection right away. If you don't do this, you will also lose this right. And there is one German court decision where a foreign award had not been challenged in the country of origin, and that was taken as a non-objection that made it impossible to challenge the validity of this award in Germany.
But do we encounter some difference also about the competencies of the courts that are involved, depending if it's a German arbitral award or if it's
Landesgericht. It's always the Court of Appeals. There is no differentiation.
Okay, thank you. That makes everything a bit easier, let's say.
Yeah, but I must admit, and this is a problem to which I have not yet found a good answer. We in Germany have, for our internal judgments, a very clear concept about what is executable. You always have to have a holding that is very specific. For example, if you have a cease and desist declaration, it must be very specific. Now, many foreign awards are not so specific. They are very broad. So they would normally in Germany be recognized. They would not be stopped, but they would encounter some problem at the enforcement stage when the party goes, for example, in the case of a cease desist declaration, to the German court, which would be the execution court. That would not be the Oberlandesgericht, and they would ask for an Estrant, which is a sum of money that the other side must pay because this party does not comply. And then you might have a problem with the specificity of the holding to cease and desist, because the specificity could have a certain bearing if you construe the requirement to be specific from a constitutional point of view.
Okay, understood. So in this case, and if you are planning to enforce an arbitral award in Germany, you really need to look out to this more or less called Bestimmtheitsgrundsatz or something like that.
I think any party that conducts an arbitration that one day could lead to an execution in Germany should take care that the holding is sufficiently specific. If you have an order for payment, this is no problem in general. But if you have an order to do something which is possible under German law, I know that it's not possible under other legal systems because they don't know this type of order. But if you have in Germany, this is possible, and then you have to be pretty specific so that you do not encounter a problem down the line where the award is recognized but not really easily enforceable because it's not specific enough.
Wow, thank you very much, Eric. So now, Heidi, I will come back to your point. That was really interesting because, of course, one of the problems that we face when we are about to enforce an international arbitral award is what happens when annulment proceedings are also being carried on in the country of origin. What happened then in Spain? Does Spain follow the French model here, or what is the situation, the legal situation in here?
I wish I had a clear and unequivocal answer to that question. No, but I can give you some hints and highlights of where we are, where our courts are heading in this regard. First of all, we have a specific provision in the arbitration law which specifies that the courts can, but do not have to, suspend the enforcement if annulment is being sought. So it's specifically stated that you can request suspension of the enforcement if you have an annulment procedure, but the courts do not have to grant it. It's not compulsory. If you wish to have the enforcement suspended, on top of that, you have to post a security. So that's two important things that have to be taken into consideration first, and that's very clear. The background is perfectly clear in our courts and in the arbitration law. So you can suspend the enforcement, but it's not a compulsory suspension if annulment is being sought. And if you request suspension of the enforcement, you have to post a security in an amount sufficient to cover the enforcement plus any damage related to the suspension of the enforcement. Now, the key question is what happens if with the recognition, and what happens if the award is annulled in its seat of origin. So we don't have specific decisions that have already addressed that issue. We have, however, two decisions that are very interesting in this regard. One dates back from 2007 and is a decision from a first instance court. But the second one is a decision that dates back from 2019 and is a decision from the Superior Court of one of the autonomous regions in Spain. So what can we deduct from those cases? In both cases, there was no annulment yet, but in both cases, the person trying to suspend the recognition or the enforcement alleged that there was an ongoing annulment procedure in the seat. What have the Spanish court looked at? So they have looked at two things, which for me are very interesting. The first one is that all the courts have agreed, and that's reiterated many times by our courts, is that the final and binding character of an award does not depend on the fact of an ongoing annulment procedure. So the award is final and binding once it's been issued and notified to the party. And for our courts, that's the only requirement that is sought for an application of recognition or enforcement to be granted. So if you want the recognition or enforcement to be denied or suspended because of an annulment, it's the party opposing the recognition and enforcement that has to prove annulment or ongoing procedure, annulment proceedings. So that's the first thing that is relevant from those decisions. The second one is that our courts have highlighted the difference between the New York Convention and the Geneva Convention of '61. As you know, both Spain and Germany are parties to the Geneva Convention, and the Geneva Convention does not have as a ground for opposing the recognition and enforcement the fact that reasons for the fact that it has been annulled or public order issues. So what do the courts infer from that? They infer that sometimes it could be annulled for reasons that are not contemplated in the Geneva Convention and still be recognized in Spain. It has never been done, and I have big doubts that it would be done if the case were to happen, but that's a statement. And the latest decision that I was mentioning from 2019, the courts emphasized again and again that the New York Convention only gave the courts the possibility to refuse recognition, but not the obligation in case of annulment. So in both cases, and that's another thing that is important, in the first one, there was no evidence of why the parties were seeking annulment, or why the opposing party was seeking annulment. In the second case, apparently the annulment had been dismissed. So you see that it's clear cases where you wouldn't have, you would have anyway recognized or enforced the award. But the reasoning of the decisions makes it appear like it could be possible for our courts to actually recognize and enforce, even if it was annulled in the seat of the arbitration, but on very limited grounds. And my intuition, knowing our courts, is that if a case like that happens, it has to be a very clear-cut case, one that would go against due process not to recognize it because it was annulled in the seat of the arbitration.
Thank you very much, Heidi, for your very informative answer. Now, Eric, I will certainly not blame myself asking you if the German follows the French model. That's why I will reword my question. And will you please be so kind to explain to us the German model in these cases when we are seeking for enforcement, but annulment proceedings are pending in the country of origin?
Well, to tell you the truth, I'm not presently aware of a case where that had to be decided. But I wonder whether really the proceedings would be staged while just the proceeding is pending. And I think that the main argument is that would allow a party that is fearing to be the object of an enforcement to protract the enforcement procedure just by starting some proceedings somewhere against the award. Yeah, because we know cases where sometimes an award is even challenged outside the seat of arbitration. We know there are courts who have annulled awards that were not rendered in the country where the award was made. So we have very many weird situations. And to some, I do not believe that the German court would enforce an annulled award if it's rendered in another country and the circumstances are, let's say, normal. Yeah, this is the same situation as in Spain, but I have doubts that the simple fact that the case is object of annulment proceedings would be sufficient for a German court to stay the enforcement proceedings in Germany.
Thank you very much.
Because you can still resist on the grounds of the New York Convention. I mean, the simple fact that the award is under challenge does not prevent the party not to raise these grounds also here. And if they have already raised them in time, they will not be the object of an argument that they forfeited their right because they sat so long silent.
Yeah, so we have also here some similarities, let's say, in both countries. I just want to remind our participants, if they want to submit any question, that you are free to submit it. I'm going to be monitoring here. Now that we are speaking about annulment of arbitral awards, we are entering into one of the most interesting topics of these conferences because also relates to the latest development in Spain and Germany about annulment of arbitral awards. And for here, I would like to discuss this in more detail, especially in the case of Spain with Joseph, because I understand that you are going to explain me how the situation now is, but how was the situation a few years ago? Because it was a lot of rumors and uncertainty affecting the attractiveness of Spain, even though it was, let's say, more Spain. But yeah, we put Spain as the whole because of some problems with annulment decisions of the superior court of the autonomous region of Madrid. Maybe Joseph, if you want to explain to us what happened and what these judgments were about, and what happened, how did those judgments affected the attractiveness of let's say Madrid or Spain?
Yes, thank you very much, Elizabeth. Perhaps it might be interesting to see before how's the structure in Spain regarding the competences of the annulment of proceeding. Heidi was already commenting the Tribunal Superior de Justicia, which is the superior court of the autonomous region of Madrid in this case. And this court is competent for the annulment of arbitral awards. As we have 17 autonomous region in Spain, you can imagine that we have 17 superior courts which are competent for this question. The decision of this superior court is final and binding, and there is no recourse possible. And there is no court competent for the unification of different criteria these courts may have. So that's the first point I want to see where we are. In Madrid, we have the Tribunal Superior de Justicia de Madrid, and which is composed by 3 judges. And unfortunately, we have one gentleman who, we don't know, he is against arbitration or whatever, but he took the annulment of awards with a big laugh, and he convinced one of his colleagues to share his opinion. And always the president of this court was against the decision. What was the reasoning of this decision? They thought, or they held, that there was a violation of the public order, given the fact that, according to these judges, there was a lack or not sufficient motivation of the award. This was against the public order, and this allows the Tribunal Superior de Justicia to enter into an evaluation of the proceeding, of the motivation, and to act at the end like a second instance. And this was even a case where the parties decided unanimously to withdraw from the annulment proceeding, where the Tribunal Superior decided that nevertheless the proceeding has to continue, notwithstanding the wish of the parties not to continue. So that's perhaps the short description of the situation where we stood up to the last year.
It was only one judgment where even the autonomy of the parties, which is very much respected in arbitration, was not observed. Or did we have more than one judgment of this Tribunal Supremo?
There were a lot of decisions of this gentleman. And I don't have the exact numbers, but there are several decisions which were rendered. And it was sufficient in order to put some doubt on Madrid as a place of arbitration. And fortunately, with the recent decision of the Constitutional Court, it was clarified what is the situation. Should I explain something about?
Yeah, could you please elaborate on this, because that was my next question. So in those cases where you, okay, as a party, then you reach an agreement to withdraw even from the annulment proceedings, and then it doesn't make any difference, and then you are still having problems to enforce this award. What kind of remedies do we have? Because you were explaining at the beginning that these tribunals, they are the more or less last instance, and then you have 17 different opinions. So where do we come together?
Okay, regarding the second point, we must say that the only region where we had the problem was in Madrid and not in any other of Spain. It must be said.
That's very good.
And secondly, as I told before, there is no recourse against the decision of this superior court. And the only way some of the parties which were affected by the decision of this court, the only way is to present amparo appeal before the Constitutional Court of Spain, with the argument that the decision in these cases is violating the constitutional right to obtain justice according to Article 24 of the Spanish Constitution. In order to see the importance of this decision, which we will comment later, in practice, the Constitutional Court normally does not accept, even for procedural reasons, an amparo appeal. And when in the last year it was known that the Constitutional Court was admitting appeal regarding such a decision against the annulment of an award, it was considered to be a positive fact that the Constitutional Court is prepared to think about it. And on the 15th of June last year, the first decision was published, where we could see that the Constitutional Court, in fact, accepted the appeal and decided, for the reason which will be explained later, that the decision of the Madrid court was against the Spanish Constitution.
What exactly did this judgment say?
Well, there are different issues. First, it was a confirmation regarding the role of arbitration in Spain. The Constitutional Court confirms the arbitration as a jurisdictional equivalent to judicial proceeding. It stated that arbitration is an heteronomous mechanism for dispute resolution with the minimum intervention of the ordinary courts, which have only a limited possibility to enter or to evaluate the arbitral award. And it is considered arbitration as the annulment procedure as an external control mechanism with very limited competences and faculties. The Constitutional Court also decided or reminded regarding the concept of the public order, which is not defined legally, and therefore there's always a risk that one judge may use the concept of the public order in order to enter into an evaluation of the award, which was what this was done by the court from Madrid in the cases. Perhaps only doesn't have to do anything with this case, but in Spain we distinguish between the public order and the economical public order, which imposes to financing institutions specific information, obligation to inform and to prepare a profile of the client and to advise the client correctly in order to help this weaker party in its financial transactions. And also this concept of the order publico económico was also used by the court from Madrid in order to annul some awards.
So are we now evidencing so due to this judgment of the Constitutional Court, some restriction in the interpretation of the concept of public order or economical public order, so giving some guidance to these courts how they should interpret this not defined concept in the future to avoid this problematic for arbitration?
First of all, it was clarified that the question of motivation or reasoning of the award is not a question of public order. It's a fact or issue which is resulting from Article 37 of the Spanish Arbitration Act, but the motivation is not a question of the public order, it's not a constitutional right. Therefore, to argue that the lack of motivation is infringing the public order, this is an argument which cannot be held in the future. Secondly, it was stated the scope of the review of the arbitral award, which can only be made in very small situation or a very small scope to do this. It can only be made when there are procedure guarantees which have not been respected. For example, fundamental due process guarantees, lex of reasoning, imperative legal rules which have not been respected, and it is unlawful to annul an award only because the court considers that the conclusions reached by the arbitrator are mistaken or insufficient, or simply because the court would have come to another conclusion. The courts are not allowed to enter into an assessment of the evidence, the legal reasoning, the conclusion, or the details of the motivation of the arbitrator. So the court cannot examine the correctness, sufficiency, or adequacy of the grounds of the award. So briefly, the main important arguments from the decision of the Constitutional Court.
So for me, from my understanding, so what this Supreme Tribunal in Madrid was doing is just understood its role as second instance, more or less. And then the Constitutional Court say like, no, there is very restrictive scope of review here that you need to observe. But the way I understood from the Derecho de Amparo or this Amparo Appeal is that the Constitutional Tribunal is not the one that's going to make the final judgments, but it's going back to this Supreme Court for them to make the judgment. Did this already happen, and how did this interesting judge decide?
Yes, it's correct. The Constitutional Court will not make the final decision. It gives the case back to the Superior Court. And as far as we could see up to now, there's only one case. It's related to the withdrawal from the proceeding from the parties. The Constitutional Court decided that the fact that the parties unanimously agreed to withdraw from the proceeding has to be respected by the court, and he can't argue that there is public, if there are really no public interest involved, he cannot say that the proceeding has to continue because he considers there is a public order. So the wish of the parties to have arbitration or not to have arbitration has to be respected and cannot be superseded by the decision of the court. There is at least one decision of the Madrid court from January this year regarding the question of the withdrawal of the parties, where the judge or the court is admitting and using the argumentation of the Constitutional Court. So we hope that in the future, the next decision of this court will respect the reasoning we learned from the Constitutional Court.
So you will say that the faith has been restored after this judgment of the Constitutional Court and giving some relief to the arbitration community when selecting Spain or Madrid as seat of the arbitration.
The dark clouds has gone and we can look to the future.
That's great. But now I would like to know in Germany if something similar has happened, because I think here some problematics by some German courts, I think also a localized problematic has appeared, but it's regarding the dissenting opinion. So here we are again in front of the reasoning, and I don't know if also public order is involved. Eric, can you please help us with this?
Well, I think it's not a localized problem, but we must admit that not all arbitral awards are good. And there are some shocking arbitral awards, and it is good that there is a certain level of control and subject to that control being reasonable and foreseeable.
So you don't have in Germany this narrow scope of review.
If you bear a moment with me, I will just tell you about 3 German cases that show you how things work. Interestingly, the constitutional rights serve as lever to control awards, as you will see in a moment. Perhaps we start with stating that pursuant to paragraph 1054(2), an award must be reasoned unless the party have agreed that it should not be reasoned. So you can dispose of this duty to reason the award, but that's a procedural rule. Moreover, rules like the DIS or the ICC rules provide that awards must be reasoned. And the question is reasoning, any reasoning? And there, the German courts say no, not any reasoning is the reasoning that is required, and the violation of this kind of procedural rule can be a ground to set aside the award. It can, of course, be then sent back to the arbitrators, for example. It's a possibility German courts have. They may exercise this right. Moreover, there is an effect of the German constitution, which we call third-party effect. You know, arbitrators are privates, and normally the fundamental rights only operate in the relationship between the citizen and the government. But as soon as you have a court judge who decides, these fundamental rights have an effect on how the judge applies the law. And this happens here. We have the right to be heard. This is enshrined in our constitution in Article 103. And there is a long-standing jurisprudence concerning state court proceedings, that state court proceedings which are surprise decisions, so the parties could not argue the case, or where there are deficiencies in the reasoning, can be annulled by the appellate court or by the federal court. So we have this control for lacks of reasoning also in state judgments. And the question is whether these standards also apply in arbitration proceedings, because German courts part from the principle that Article 103 also applies to arbitration proceedings, which is interesting. It's not necessary, but logical, but this is the position because they have this third-party effect doctrine. And apparently they take arbitration serious, and they see it as a real substitute to the state court jurisdiction. Now, there is a decision by the Munich Court of Appeal, and they deal in their case of November 9, 2015, and the reference is 34 SCH 2714. They state, the arbitral tribunal also did not violate the obligation to state the reasons for the arbitral award as prescribed under section 34.3 of the DIS rules in accordance with section 1054 second paragraph of the ZPO, also in terms of content. Less strict requirements are to be placed on the statement of reasons for arbitral awards than on the statement of reasons for state court judgments. Therefore, the case law on the absolute grounds for appeal of a lack of reasons for the judgment, which is in paragraph 547 of the ZPO, which is not applicable in arbitration proceedings, cannot be relied upon for the assessment of a significant lack of reasons. Rather, the question whether the statement of reasons for an arbitral tribunal due to the use of merely empty phrases, perplexity, or for other reasons is equivalent to the absence of a statement of reasons at all, is to be assessed according to the purpose of the obligation to state reasons. So you must provide full reasons, you must reflect the essential arguments, but it's not really necessary to do this without any fault in application. There is another judgment of the Hanseatic Court of Appeals of June 8, 2001. This is 11 SCH 0101, where they state such a ground for annulment does manifestly not exist in the instant case. A deficit in reasoning in this sense does not already exist if a judicial review of individual issues in the reasoning results in the conclusion that another view would have been more correct. What is required is a basic manifest default in the reasoning that equates to a complete absence of reasoning. Now, this sounds a bit like this US doctrine, manifest disregard of the law. So we see there must be some deficit, but it must be really very obvious and compelling deficit that is easily perceived. And that can lead to the annulment of an award on these grounds, which are the lack of reasoning seen in the light of a violation of the right to be heard. Because the lack of reasoning shows that the arbitrators did not take into consideration the arguments of the party. Now we have a recent decision by the Frankfurt am Main Court, which is dated, let me have a look, on January 16, 2020. And this is reference 26 SCH 1418. And there, in a very complex merger acquisition dispute, apparently the arbitration tribunal relied on figures in an expert report that were outdated and which apparently didn't any longer serve the purpose of providing an actual value for the moment in time when the valuation had to take place within this arbitration. And there, the Frankfurt court says this is such an eclatant non-observance of what the parties argued that the award must be vacated. What is interesting in this decision is it's about 40 pages, and you have out of these 40 pages, 25 pages of all the grounds on which the parties relied and which were no grounds of setting aside, and then they found this single ground to set aside the award. And what is also interesting in this decision is that there is an arbiter dictum, and this was an ICC arbitration that should be added. There is an arbiter dictum that seems to indicate that the court considered that a dissenting opinion that had been notified in that case could also be a ground for annulment because it would equate to a breach of the secrecy of the deliberations. However, the court has left this open, and it's very strongly criticized, and it also finds no basis in the source, which is in the legislative materials on which the court relies. So it is not clear whether that court, in a case where this would need to be decided and would be decisive, would really still decide in that way. They have left this open, but they have stated that could be a possibility. So what we are left with is a very strange case where, in my opinion, the decision to annul the award in view of the application of these old figures is questionable. And that shows something very important. In the end of the day, these cases depend very much on how they are argued, and they are very much fact-driven. And somehow in this case, there is a very weird element that must have appeared to this court to be very shocking. But it's not necessarily, if you apply, and they all apply the same criteria, if you apply these criteria, it does not appear to me to be really a case where there was a must annulment. It was just one position the court could take. And I do not know what the Federal Court of Justice will decide in that regard, whether it will confirm that decision or find that it was erroneous.
Thank you very much, Eric. Even though I would like to comment a lot on this, very interesting, because it caused in uncertainty at some point what the German will recognize as enough reasoning and so on, and what's a good award and whatnot. We are running out of time, and I would like to read the one interesting question of one of our attendants, and I guess is most related to Joseph. So, do you think that the recent judgment from the Spanish Constitutional Court in 2020 and 2021 might be interpreted to limit the ability of Spanish courts, Tribunal Supremo de Justicia, to raise sua sponte procedural public policy grounds for annulment, right of defense under Article 24.1 of the Spanish Constitution? In my opinion, such grounds should have been diligently raised previously by the parties, and in the absence of a specific procedural public policy, such as a restriction or arbitration clauses in consumer contracts, the affected party has forfeited such procedural challenge. What is your opinion on here, Joseph? I think it was a hard one, a very good one.
It's an interesting question. No, I don't know what was the precise reasoning the parties made alleging Article 24 in this case, but I think that the reasoning made by the Constitutional Court protects the interests of the parties to manage their arbitration proceeding according to their wish and their purpose they want to do.
Okay, thank you very much. Yes, Eric?
May I add something, because that might be of interest to our Spanish participants. Of course, the ground of public policy as ground for non-recognition or setting aside does also exist in Germany. Logic. Yeah. What is to be said is that not any violation of German mandatory law will result in a violation of public policy. The concept of public policy can be found, and it's essentially the same concept in paragraph 328, first paragraph, number 4 of the German introductory law to the Civil Code, Article 6, EG-BGB. And there, the public policy comprises German and international public policy. And the violation of public policy will require that the award violate a norm that governs the foundations of economic or governmental life, or that the execution of the award would manifestly lead to a result that is incompatible with the substantial principles of German law, which include inter alia the constitutional right to be heard. Now, that's the loop back. The right to be heard is sacrosanct in Germany, in a way. You have just heard it when they interfere with the lack of reasoning in the award. But this is a definition of public policy. Of course, for example, European antitrust law, a violation thereof, would normally be considered in Germany as a violation also of German public policy. But in other fields, a simple non-dispositive norm that is mandatory for the parties would not automatically equate a violation of German public policy.
Thank you very much, Eric. Unfortunately, I just took over some minutes from the closing remarks, and we now need to move over. But it was very, very interesting, and a lot of insights and information I was able to gather. I hope also our audience is very pleased with all these details and information you have provided us, and with the explanation. It really helped me. So thank you so much, Eric. Thank you so much, Heidi and Joseph, and also for the questions. And Thomas Sullivan, I think we already answered your questions. So exactly, Heidi just did it. So finally, we will have the closing remarks from Mr. Andreas Heinrich, who is a lawyer and tax consultant at Flick, Gocke und Schaumburg in Bonn, Germany, and who is also a DIS 40 regional coordinator for Rhine-Ruhr region, and from Mr. Victor Gamero, who is the head of international relations at the Madrid Bar Association. So the floor is yours. And sorry for running over.
Thank you very much, Elizabeth, for the kind introduction. And of course, thank you to the members of the, I almost said tribunal, to the members of the panel for giving us such interesting and comprehensive insights into the various topics of the day. To finalize today's event, or rather to summarize, I should say, we have heard, I think, 2 different main topics that compared Spain and Germany as seats of arbitration, both from a legal standpoint and also from the institutional standpoints, i.e. comparing the DIS and the MIAC as arbitral institutions. Going forward with the legal aspects, I think we have learned that there are many similarities, both of a practical and a legal nature, between Germany and Spain, seats of arbitrations. Obviously, both are rooted in Europe and both have civil law legal systems. So we have a joint tradition, if you will. Both legal or both arbitration laws, I should rather say, are based on the UNCITRAL model law. Both states are members of the New York Convention, longstanding, and both countries do not really differentiate between national and international arbitration proceedings. So both are accepted at the same level. Both states obviously have certain court measures that go into assisting arbitral tribunals, going forward with the procedure and taking evidence. And of course, a big topic that was also discussed today, the annulment of awards in case that is regarded as necessary. Generally, I think that both countries do have a rather arbitration-friendly court practice. In Spain, perhaps, except for the region of Madrid, or until recently at least, if I had understood it correctly. And luckily, Spain appears to have a reliable constitutional court that does step in when things or certain judges get out of hand, if I may say so. So we will see in the future whether, if any damage to the Spanish reputation as a seat of arbitration had been done in the past, whether this damage has been rectified by the Constitutional Court. It at least does appear to be the case in my personal opinion. With regard to the recognition and enforcement of arbitral awards in Spain, there seems to be certain, at least from a German perspective, some formalistic approach to certain issues with regarding to the notarization of the award itself. But then again, the remedies in case, the repercussions in case there's anything missing don't seem to be that severe. So it's still possible to correct any missing formalities within, of course, the time that is before the expiration of the 5-year period. In Germany, of course, there seems to be a certain the enforcement of awards, or at least of foreign arbitral awards, sometimes may be difficult with regards to the principle of specificity of the award. Germans tend to be somewhat specific in some sense, and of course, I think you, Eric, mentioned it. The question of whether including a dissenting opinion in the award or publication of it does constitute in Germany a grounds for annulment or possible grounds for annulment, that I think is, at least on an international level, does pose a questionable issue, because I absolutely agree with you. There is no, in my personal opinion, no legal grounds for transferring that principle that applies to state judges to private arbitration tribunals, but the German courts have been restricting or strict with that issue. This concludes my legal aspects for a short comparison of the DIS to the MIAC. The DIS began with its predecessor institutions over 100 years ago as a national arbitration institution, and now almost 50% of cases have become international cases, or at least cases where foreign parties are participating. Both or the DIS does not really have a focus on Latin America and Spanish cases. We have heard that only very few cases do concern Spanish-speaking parties. The rules of the DIS have been last updated in 2018, and one specificity of these rules is the case management conference that we have heard, so that we have the ability to or the attempt to organize the case, the procedure individually to the party's needs at a very early stage in the proceedings, with certain mandatory aspects that have to be discussed within this conference. With regards to the MIAC, the MIAC is compared to, as opposed to the DIS, has started as or it began as an international arbitration institution from the outset. It's only 1.5 years old, so we will see whether its goal to become one of a larger international arbitration institution can be achieved. I think it does has a great potential, as the 3 founding institutions behind it have a vast experience, and they're trying to channel basically Spain's international focus. I expect it to be more on the Latin American level, but obviously this can be a gateway for Latin American parties to have their seat of arbitration somewhere in Europe, and also for German parties engaging with Latin American parties, it might be interesting to have a seat in Spain and applying the MIAC rules in case that would apply. The MIAC rules, obviously being relatively new, are adhere to the modern standard and contain the rules that we knew, that we or consider the aspects that we think are important today, such as multi-party arbitrations, multi-contract things, and so forth. And one aspect that I find very particular with regards to the MIAC rules is the possibility, such as an opt-in possibility, to have an appeals process, an appeals tribunal, sort of, if I understand it correctly, as a second instance, something which is not completely unknown in arbitration in Germany, but is rather unusual, and I think is a very interesting aspect to go forward. That being said, I think this event has been very interesting. Thank you again to the speakers of today. And now I give the word over to the principal organizer of today's event, Victor. Thank you very much.
Thank you very much, Elizabeth, and thank you very much, Andreas. Good afternoon, everyone. I promise I will be brief because we've been having a long time here. First of all, I'd like to thank the German Arbitration Institute and the Madrid International Arbitration Center for inviting me to participate today in this event. It's been a very interesting webinar. We had an exciting discussion with great interventions of the panelists and questions from the attendees. So congratulations to our moderator today, Elizabeth, and our 3 main speakers, Eric, Heidi, and Joseph. Let me please say that I feel happy and honored to be here, to participate, and not only for having the pleasure to conclude the event, but also for seeing this type of events taking place frequently. And I say this because, believe it or not, these virtual events are of great importance because they are our current platform that keep us and allow us to keep having and engaging in meaningful conversations with our colleagues from all parts of the world. And in this case, it enables us to continue promoting the use of alternative resolution mechanisms. And specifically with regard to this second point, the promotion of ADR mechanisms. In this case, we talked a lot about arbitration, but I like to say that, in my opinion, all practitioners or legal practitioners should raise awareness of the multiple advantages of this particular ADR, but as well of the other ADR methods. It is in benefit of everyone, and it shouldn't be only on our shoulders. In addition to that, the challenges we face today due to the COVID-19 outbreak have precisely emphasized the advantages of arbitration. Nowadays, more than ever, the flexibility and efficiency of arbitrations play a vital role for businesses and individuals in the context of dispute resolution. Today, our speakers did a fantastic job going over several different issues, such as competent courts for the annulments of arbitral awards, the past problems with the annulments, the interpretation of public order in the arbitration context, or the relevance of the party's decision to withdraw from the annulment procedure. All these views, all these insights gave us and give us a clear picture of the current arbitration context, its problems, the complexities of the two jurisdictions. But I like to also say from a Spanish perspective, especially for the ones seeing us out of Spain or those unfamiliar with our jurisdiction, I like to say that Spain has historically been an arbitration-friendly jurisdiction with a favorable legal framework and a judicial system supportive of arbitration. So these recent constitutional rulings commented earlier very well by our panelists, they came to put an end to possible expansive interpretations of that famous public order that we face here, as well as to confirm the set-aside proceedings in Spain are not to be assimilated in any manner with a second instance on the merits. So obviously, these constitutional decisions were very welcomed, I would say, from the Spanish arbitral community to clear up any possible doubt. But I have to say that these decisions are not only beneficial to the professionals involved in arbitrations, lawyers, experts, arbitrators, secretaries, court. These decisions are very positive for the justice system in general, since it is important now to bear in mind that before COVID arrived in our lives, at least the Spanish system and to my knowledge, many justice systems were dealing with the excessive workload. At least in our case, the risk of a huge or of a great collapse, it is real. It is real, and we have to avoid that at all costs. Because of this and all the solid elements commented by our speakers today, I think we should be delighted to be able to say that both Germany and Spain are reliable seats of arbitration. To the benefit of this cause, it is very positive to see these two leading arbitral institutions, this and MIAC, collaborate actively in the promotion of arbitration and the rest of ADR mechanisms, and as well to promote their two jurisdictions as seat of arbitration. With all that said, I try to be brief. I just like to say thank you to all of you for making this possible. Congratulations.
Thank you.
Thank you all.
Bye-bye.
Yes, thank you.
Bye.
Thank you. Bye-bye.
Thank you very much.
Thank you. Goodbye. Was a pleasure.
Bye.